Hello everyone. This lecture series has been brought to you as a courtesy of Raj Malhotra's IAS Institute, Chandigarh. It is for all the students who are looking forward to take Punjab University's 5-year or 3-year law entrance exam. Since the syllabus of both these examinations is same, we have brought to you an integrated course to cover up the entire syllabus completely free of cost. This is Ayush Gupta. I am a graduate from Punjab University's Law Department itself, and I will be covering up the legal aptitude section of this entrance exam. The only difference between both the examination is with respect to the number of legal aptitude questions that will be asked. In 5-year law entrance exam, out of 100, 20 legal questions will be asked, whereas in 3-year law entrance exam, about 40 questions will be asked. Now, let us have a look at the syllabus of legal aptitude. So, at the top, we have the Constitution of India. This is perhaps the most important segment of this section. Maximum number of questions are asked from the Constitution, and therefore, we are going to cover up important topics from this section in a detailed manner. Then we have contracts, torts, criminal law, Muslim and Hindu law. Now, out of these 4 laws, we are not required to go into extreme depth of these laws. We have to have a complete overview and knowledge of these laws and things they deal with, along with some important provisions of them. And then we have the landmark judgments. We can easily expect 1 to 2 questions directly being asked about landmark judgments. Most of these judgments will be covered while we study the Constitution itself. However, if any of the judgments are left, we'll definitely cover it up. Then we have legal GK. Now, legal GK comprises both static legal GK and current legal GK. When I speak of static legal GK, questions such as who was the first Chief Justice of India, who was the constitutional advisor, who was the first female judge of India can be asked. And when we speak of the current legal GK, the present questions such as the contentious farm bills, name 3 of them, could be asked, and likewise. Then we have legal maxims. Now, legal maxims are legal sayings in Latin, and we will be covering them in a separate video. Along with that, we will provide you with a separate document for the same as well. So, let us speak of what we are going to do today. Today, we are going to begin with the Constitution of India. Now, before we begin with it, it is extremely important to have a knowledge about the background of the Constitution of India, about the laws which were governing the country before the Constitution of India came into effect. Although, from the examination point of view, this segment holds very little, I'd say very little importance. However, in order to cover the topic properly, we need to have a brief idea as to what were the legal enactments which were in place before Constitution came in. Now, I have divided these legal enactments into 2 parts. One are the legal enactments before 1857, that is, before the First War of Independence, because before the First War of Independence, it was the company that was ruling the country. Thereafter, we have the British government who was ruling the country. So, in 1600, Queen Elizabeth I granted East India Company the charter providing it with a monopoly over Indian trade. चार्टर यानी फरमान, मोनोपोली यानी एक अधिकार। सो क्वीन एलिजाबेथ के इस फरमान के द्वारा ईस्ट इंडिया कंपनी को ब्रिटेन से इंडिया के अंदर व्यापार करने का एक अधिकार मिला, मोनोपोली मिली। By the end of Battle of Plassey in 1757, the East India Company had gained a formidable ground in India. After the Battle of Plassey, the revenues of the East India Company grew enormously and they came in the attention of the British Parliament. Seeing the extreme success of the company and the expansive work it was doing, the British Parliament thought of regulating the affairs of the company, and therefore came the Regulating Act of 1773. Through this very act, the Governor of Bengal was made the Governor General of Bengal. The East India Company had three presidency towns. One was Bengal, the other being Madras, and the third one being Bombay. Through this very act, by making Governor of Bengal as Governor General of Bengal, the presidency towns of Bombay and Madras were brought subordinate to the office of Governor General of Bengal. This act also provided for establishment of a Supreme Court at Calcutta, which was thereafter established in 1774. Then we have the Pitt's India Act of 1784. This was a very important act from respect of the fact that through this act, the company's territories in India were now called British possessions, and supreme control was given to the British government over the company's administration, which meant that now the British government was going to keep checks on the administration of the company. Thereafter, we have the Charter Act of 1793, Charter Act of 1813, and Charter Act of 1833 and Charter Act of 1853. Through these Charter Acts basically served as a lifeline for the company's time in India. With every Charter Act, the company's rule in India was extended for 20 years. For example, through the Charter Act of 1793, the monopoly of companies' trade over India was extended for another 20 years. Through Charter Act of 1813, this monopoly of the company came to an end. However, it was given yet another 20 years to do its commercial and administrative activities in India. Through Charter Act of 1833, the first important thing that was done was Governor General of Bengal was now made Governor General of India, which meant that now not only were the presidency towns of Bombay and Madras subordinate to the office of Governor General of India, however, their legislative powers were also taken away. Now, they could also not make laws. So, over here, we find a centralizing tendency. Power has been centralized in one office through these acts. Also, through this very act, that is, Charter Act of 1833, the company's commercial activities were stopped. Now, the company was only allowed to function as an administrative body. Through Charter Act of for another 20 years. Through Charter Act of 1853, now this Charter Act was the end of lifeline of company, in a manner that this Charter Act did not specify for how long the company would now be ruling. It just said that until further notice, the company would be ruling India. The another thing that was important with respect to this act was that through Charter Act of 1853, the Indian civil services were opened for Indian people to take. Then we have the war, the first war of independence, that is 1857. Right after the first war of independence of 1857, the British Crown realized that now it was beyond the company's ability to rule India peacefully, and therefore, through Government of India Act 1858, the British Crown abolished the company and took over the administration of India directly into its hands. The office of Governor General of India was ended and he was made the Viceroy of India, that is, the representative of the Crown in India. An office of Secretary of State for India was created in the British Cabinet. This is like just another minister in our cabinet, like a minister for railways, a minister for Northeast region. In the similar vein, Secretary of State for India was the highest authority to deal with the affairs in India and manage them. He was to be assisted by a 15-member council. Then we have the Indian Councils Act 1861, Indian Councils Act 1892 and Indian Councils Act 1909. By this time, the Britishers had realized that they could not rule India without cooperation from the masses, and therefore slowly the masses were started to representatives of masses were started to be incorporated into the legislative affairs of the company, though at a very slow speed. Out of these three acts, the very important thing that we need to remember is the Indian Councils Act 1909, also known as Montague reforms. Now, Morley was at that time the Secretary of State for India and Minto as Viceroy of India. Through this act, separate electorates for Muslims were introduced. What does separate electorate mean now? In India, we are familiar with the concept that certain seats, जब election होते हैं, तो reserved होती हैं कुछ castes के लिए. However, although उन seats के ऊपर से MLA या MP के लिए सिर्फ a member of that caste could stand. However, all of us will be voting for that individual. In case of communal electorates, it is not the system. In case of communal electorates, only the members of that very particular caste will be allowed to vote for that very individual, and others will not. Therefore, this draws a line between communities, and hence Lord Minto was also known as the father of communal award. Thereafter, we have the Government of India Act 1919, also known as Montague-Chelmsford Accord. Now, the Montague-Chelmsford Accord is known, it divided the powers between the central and the provincial assemblies, and also introduced the system of diarchy, which is two governments, dual government in provincial setup. When I speak over here about federal government and provincial, imagine I am talking about central government, Modi ji ki government, and state government, Kejriwal ji ki government, Gehlot ji ki government, Stalin ji ki government. So, in this very manner, administrative powers were divided between the federal and the provincial units, and also at the provincial level, diarchy was introduced. Diarchy means dual government. Diarchy में concept था transferred और reserved subjects का. अब transferred और reserved subjects के अंदर क्या फ़र्क है? Transferred subjects वो subjects थे जिसके ऊपर executive action ले सकते थे elected ministers, जो कि elected members होते थे Indian community की तरफ से. and on reserved subjects, the people nominated by the provincial governor would only take the decisions. Now, out of the funny part about this is, all the subjects which were of lesser importance and which were necessary, which dealt with duties of the state towards the people, were put in transferred subjects such as sanitary, such as health services, safai, municipalities. For that matter, if we read history properly, we will get to know that most of our leaders, even Pandit Jawaharlal Nehru, these were mayors of municipalities at their earliest stage in political life. Whereas the reserved subject had all the more powerful subjects such as the home department, the police department, the finance department. Moving forward comes the Government of India Act 1935. Now, Government of India Act 1935 was the result of 3 round table conferences. Through this very act, the powers of the center and the units were divided into 3 lists. Number 1 was the federal list, which had the subjects over which the center can make laws. Then we had the provincial list for the states, over which the states can make law. And then we had the concurrent list. These are the subjects over which both the center and the states could make laws. The residuary powers were left with the Viceroy of India. Now, over here the question comes, what are residuary powers? Residuary powers यानी बची हुई powers. अब बची हुए subjects कौन से होंगे? इन बचे हुए subjects का कोई नाम नहीं था उस टाइम पे. With the development of society, new things come up, and allotting residuary subjects to an authority tells us that we had the vision and we have the knowledge that in future new things can come up about which we might not have thought beforehand. And then in that scenario, who will take decisions over that? For example, if at that time nuclear power came up, the nuclear invention came up, then who would be making decisions with respect to that? So this is the meaning of residuary powers. So whatever, even if this invention of computer or anything else, it would have been the Viceroy at that time who would be taking the decisions. And then we have the Indian Independence Act of 1947. Through this very act, India was given independence. India was also partitioned between India and Pakistan, and was also given the power to form a constituent assembly and prepare a constitution for itself. With this, we now come forward to the constitution. However, in these 2 slides, the important things, very important things that we need to remember are with respect to the Indian Councils Act 1909, that is that of separate electorates, and Government of India Act 1919, Montague Chelmsford reforms with respect to the system of diarchy, and the Government of India Act 1935 with respect to division of subjects between center and states into 3 lists. This thing was directly taken up by our present constitution, the system of providing of 3 lists dividing powers between center and states, and it is incorporated into the constitution. Now, today we are going to begin with the preamble to the constitution, also known as introduction to the constitution. Sir Ernest Baker Ernest Baker, defined in the preamble as a keynote to the Constitution. Preamble लिया कहाँ से गए आप? When the Constituent Assembly was established for making our Constitution, संविधान सभा का जब गठन हुआ हमारे संविधान को बनाने के लिए, तो किसी भी सभा का जब गठन होता है तो हमें उसके उद्देश्यों को पहले रखना पड़ता है ताकि सभा अपने काम में कभी भी इधर उधर ना हो जाए। एंड ये काम किया था पंडित जवाहरलाल नेहरू ने। पंडित जवाहरलाल नेहरू ने ऑब्जेक्टिव्स रेजोल्यूशन रखा हमारी कॉन्स्टिट्यूएंट असेंबली के सामने। ये ऑब्जेक्टिव रेजोल्यूशन उन सारी बातों की बात करता है जो कि आज हम इस प्रेएम्बल में देखते हैं। वेरास जो प्रेएम्बल था वो सारा कॉन्स्टिट्यूशन बनने के बाद इनकॉर्पोरेट किया गया कॉन्स्टिट्यूशन में, सो दैट इट कुड रिफ्लेक्ट द एंटायर स्कोप ऑफ कॉन्स्टिट्यूशन इन इट। फ्रॉम द प्रेएम्बल वी हैव 4 questions that are generally asked and 4 things that it generally informs us about. Number 1, what is the source of authority of the Constitution? By reading the very first line, we get the answer of it. We the people of India. Now come to the last line. Adopt, enact and give to ourselves this Constitution. From the first and the last line, we get to know from where does the Constitution derives its authority. It doesn't derive it with the Indian Independence Act of the Britishers. It doesn't derive this authority from its power from Queen of England. Neither does it derive its authority from any freedom fighter. However, it derives its authority directly from the people of India. The second question that the preamble answers is as to what is the nature of Indian state. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. So here is what the nature of Indian state would be. Indian state would be a sovereign nation. Sovereign यानी जो किसी के अधिकार जो किसी के लिए जवाबदेह नहीं है अपने किसी भी एक्ट के लिए। सॉवरेनिटी का मतलब होता है कि जब आपकी देश की सरकार इंटरनल डिसीजंस और एक्सटर्नल डिसीजंस लेने में इंडिपेंडेंट हो। It doesn't have to take permission from the British Crown or America or anyone. And then Indian state would be a socialist state. Socialism का जनरल शब्दों में मतलब ये होता है कि जो प्रोडक्शन के सारे रिसोर्सेज होते हैं, प्राइवेट प्रॉपर्टी होती है, वो अबॉलिश होती है और प्रोडक्शन एंड डिस्ट्रीब्यूशन के सारे रिसोर्सेज इन द हैंड ऑफ स्टेट होते हैं। स्टेट सब कुछ कंट्रोल करती है। फॉर एग्जाम्पल चाइना। हाउएवर इन इंडिया द फॉर्म ऑफ सोशलिज्म दैट वी हैव अडॉप्टेड इज डेमोक्रेटिक सोशलिज्म। डेमोक्रेटिक सोशलिज्म अब क्या होता है? डेमोक्रेटिक सोशलिज्म होता है जब स्टेट हो एक वेलफेयर स्टेट। स्टेट का उद्देश्य होगा लोगों का भला करना एंड साइड बाय साइड प्राइवेट सेक्टर विल ऑल्सो बी अलाउड टू एग्जिस्ट. So the entire resources will not be in the hand of the state, and we have a model of mixed economy, combination of both public, sarkari and private sector. Ours is a secular country. सेक्युलर कंट्री का मतलब है कि हमारे देश का कोई धर्म नहीं है. इंग्लैंड का धर्म है क्रिश्चियनिटी, एंड ऐसे ही बहुत सारे देशों के अपने अपने नेशनल रिलीजन्स हैं. ना तो हमारे देश का कोई धर्म होगा और ना ही हमारे देश में धर्म के आधार पर किसी के साथ भेदभाव होगा. देन आवर्स वुड बी ए डेमोक्रेटिक स्टेट. डेमोक्रेटिक स्टेट है अब्राहम लिंकन की एक डेफिनेशन है डेमोक्रेसी की, जो कि बहुत फेमस है. government of the people, for the people and by the people. गवर्नमेंट जनता की, ऑफ द पीपल, फॉर द पीपल। गवर्नमेंट किसके लिए? जनता के लिए ही। जनता की गवर्नमेंट जनता के लिए, और कहां से? जनता से ही आएगी ये गवर्नमेंट। गवर्नमेंट ऑफ द पीपल, फॉर द पीपल, बाय द पीपल। And then ours would be a republic. Republic is those states where the head of the state is elected and not nominated or hereditary. For example, in United States of America, the president is elected. In India also, the president is an elected president. We don't know as to who will be our next president. लेकिन हमें ये ज़रूर पता है कि इंग्लैंड का किंग अगला किंग प्रिंस चार्ल्स ही होंगे। So in this manner, this tells us the nature of Indian state. The third thing that preamble tells us is about the objectives of constitution. Constitution चाहता क्या है? Constitution चाहता है न्याय, हर तरीके का न्याय, सोशल, इकोनॉमिक, पॉलिटिकल। सोशल यानी सोसाइटी में भेदभाव ना हो, अनटचेबिलिटी जैसा कुछ ना हो। इकोनॉमिक यानी इनकम डिस्पैरिटी कम हो, पॉवर्टी से अभाव आए लोग अपने आप को खुद सेल्फ सफिशिएंट रह पाएं। पॉलिटिकल, सभी के पास गवर्नमेंट ऑफिस के लिए वोट करना और खड़े होने का भी अधिकार है, यूनिवर्सल एडल्ट फ्रेंचाइज। देन लिबर्टी, एवरी इंडिविजुअल शुड हैव लिबर्टी ऑफ थॉट, सोचने की, अपने आप को एक्सप्रेस करने की, कोई भी धर्म को में मानने और किसी भी भगवान की पूजा करने की। ये सभी चीज़ें हमारे कॉन्स्टिट्यूशन में इनकॉर्पोरेटेड हैं। इक्वालिटी ऑफ स्टेटस एंड ऑफ अपॉर्चुनिटी। इक्वालिटी ऑफ स्टेटस का मतलब ये नहीं है कि भाई उसके पास भी मर्सिडीज़ है तो आपके पास भी मर्सिडीज़ होगी। इक्वालिटी ऑफ स्टेटस का मतलब है कि कानून की नज़रों में आपकी इक्वालिटी है, आपके साथ कोई भेदभाव नहीं किया जाएगा जब आप स्टेट के पास आएंगे। एंड ऑफ अपॉर्चुनिटी, सभी को इक्वल अपॉर्चुनिटी दी जाएगी किसी भी अपनी ज़िंदगी में आगे बढ़ने के लिए। जब हम इक्वालिटी की बात करते हैं तो एक चीज़ को हमें ध्यान से रखना है। इक्वालिटी का मतलब होता है इक्वालिटी अमंगस्ट इक्वल्स एंड नॉट अनइक्वल्स। अगर एक इंडिविजुअल बहुत ज़्यादा गरीब है और एक इंडिविजुअल सामान्य परिवार से बिलोंग करता है, तो ये मानना कि दोनों के लिए कंपटीशन रख दिया और दोनों ही उसे खुला है दोनों के लिए कंपटीशन, तो दोनों को हमने इक्वालिटी से ट्रीट किया, तो ये गलत होगा। इसी कारण से अलग अलग तरीके के प्रोविजंस बनाए जाते हैं, रिजर्वेशंस दी जाती हैं स्कूल्स में एंड और सारी जगह, ताकि दूसरे तबके के लोग भी ऊपर उठ सकें। And to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Given the fact that our nation is so diverse, it is very essential for us to ensure brotherhood. Fraternity का मतलब भाईचारा, क्योंकि अगर ये भाईचारा नहीं रहेगा तो इस देश का रहना बड़ा मुश्किल हो जाता है, या शांति से जीना बहुत मुश्किल हो जाता है। And unity and integrity of the nation. Integrity शब्द इसलिए इंक्लूड किया गया था ताकि ये बताया जा सके so as that it is not possible to disintegrate this country. It was a sign given to the separative tendencies जो कि चाहते थे, ऐसी ताकतें जो कि इस देश को अलग करना चाहते थे, तोड़ना चाहते हैं। 3 words we have to give extreme importance over here, that is socialist, secular and integrity. Now socialist, secular and integrity, these 3 words were not part of preamble when the constitution was enacted. These were made part of the constitution by the 42nd Amendment Act. Now अमेंडमेंट क्या होती है? जब हम कॉन्स्टिट्यूशन के फीचर्स की बात करते हैं तो हम अपने कॉन्स्टिट्यूशन को कहते हैं कि आर्स इज अ कॉन्स्टिट्यूशन जो कि रिजिड भी है, फ्लेक्सिबल भी है। फ्लेक्सिबल कैसे है? फ्लेक्सिबल होने का यही मतलब है कि वक्त के साथ एंड ज़रूरतों के साथ हम अपने कॉन्स्टिट्यूशन में बदलाव कर सकते हैं, अमेंड कर सकते हैं, उसे बदल सकते हैं। और इसी संदर्भ में कॉन्स्टिट्यूशन अमेंडमेंट 42 ने इनकॉर्पोरेट करे हमारे प्रियम्बल में सोशलिस्ट, सेक्युलर एंड इंटेग्रिटी। नाउ द लास्ट क्वेश्चन that preamble answers is the date of adoption of the constitution. Now remember, it is not 26th January 1950. However, it is 26th November 1949 when the constitution was adopted. 26th November is also known as the Law Day or the Constitution Day. Now, apart from knowledge of all these things, these 4 questions, that is, from where does the Constitution derives its authority, the nature of the Indian state that the preamble tells us about, the objectives of the constitutions that the preamble tells us about, and the date for the adoption of the constitution which the preamble tells us about, we also need to learn this preamble ad verbatim. Ad verbatim मतलब शब्द टू शब्द, वर्ड टू वर्ड हमें ये याद करना पड़ेगा। उसका कारण क्या है कि many a times direct questions are asked from the preamble. They can ask you, the preamble gives us justice of which 3 types? We have to tell them social, economic, political. They can ask you to tell the correct order in which sovereign, socialist, secular, democratic, republic is written. And therefore, we need to learn this from very thoroughly. Because we be assured that 1 or 2 questions will always be asked from this topic. Now, another 2 things that we need to know about the preamble is preamble part of the constitution? जब हम कोई किताब खोलते हैं तो हर एक किताब के आगे इंट्रोडक्शन का पेज होता है, वैसे ही कॉन्स्टिट्यूशन का इंट्रोडक्शन का पेज है प्रियम्बल। लेकिन अब ये हमें सोचना पड़ेगा कि क्या ये इंट्रोडक्शन का पेज हमारे कोर्स का भी पार्ट है? तो बेरुबारी अब तो ये चीज सबसे पहले सोची गई, डेलिब्रेट करी गई सुप्रीम कोर्ट द्वारा इन द केस ऑफ बेरुबारी यूनियन 1960। इस केस में ऑनरेबल सुप्रीम कोर्ट ने यह तो माना कि कॉन्स्टिट्यूशन को समझने के लिए प्रियम्बल बहुत जरूरी है, लेकिन it held that preamble is not part of the constitution. This question again came up in the very important judgment. Perhaps हमारे कॉन्स्टिट्यूशन के इस लेक्चर सीरीज के दौरान इस जजमेंट का नाम आगे 10 बारी आने वाला है। तो आप एक टेबल बना सकते हैं लिख के, केशवानंदा भारती वर्सेस यूनियन ऑफ इंडिया, एंड जब जब मैं इस केस के बारे में मेंशन करूंगा तो आप उस टेबल के आगे लिखते रहिए कि ये इस जजमेंट में क्या क्या इम्पैक्ट किया। सो पहला जवाब जो इस जजमेंट ने दिया वो था विद रिस्पेक्ट टू प्रियम्बल। नाउ इन केशवानंदा भारती वर्सेस यूनियन ऑफ इंडिया in the year 1973, it was held that preamble is a part of the constitution, number 1. Number 2, the another question was, can the preamble be amended? Now, if the constitution article 368 जो कि amendment provisions हैं जिनके बारे में हम किसी और लेक्चर में पढ़ेंगे आगे, पावर देता है सेंट्रल गवर्नमेंट को कॉन्स्टिट्यूशन अमेंड करने के लिए, देन अगर प्रियम्बल कॉन्स्टिट्यूशन का पार्ट है तो क्या प्रियम्बल को भी अमेंड किया जा सकता है? बदला जा सकता है? तो इसका आंसर बिल्कुल ही यस है. दैट इज व्हाट द सुप्रीम कोर्ट सेड in Keshwananda Bharati versus Union of India, that yes, the preamble can be amended, however, subject to the fact that its basic features are not taken away. केशवानंद भारती वर्सेस यूनियन ऑफ इंडिया ने एक बहुत बड़ी डॉक्ट्रिन दी थी, बहुत बड़ी एक डिसीजन दिया था, जिसे कहा जाता है बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन. यह आप लोगों के लिए एक होमवर्क है. आने वाली लेक्चर की सीरीज में इसके बारे में ज़रूर बात होगी. सो आपको कभी भी अगर फ्री टाइम लगे तो आप बेसिक स्ट्रक्चर ऑफ कॉन्स्टिट्यूशन के बारे में पढ़ने की कोशिश करें. सो दीज वर द टू क्वेश्चंस. नंबर 1, इज प्रियम्बल पार्ट ऑफ द कॉन्स्टिट्यूशन? यस. कैन द प्रियम्बल बी अमेंडेड? यस. नाउ another two things that I've just missed out with respect to the preamble. If a question comes up that does the preamble give any special power to the government, then the answer is no. Neither does the preamble give any special power to the government, nor does it take away any power from the government. ठीक है? Because preamble एक स्टेटमेंट है. प्रियम्बल एक आर्टिकल नहीं है. प्रियम्बल के अंदर कोई डायरेक्शन नहीं दी गई हुई है. प्रियम्बल का यूज कब होगा? प्रियम्बल का यूज एज पर केशवानंद भारती जजमेंट तब होगा जब कॉन्स्टिट्यूशन के किसी प्रोविजन को हमें समझने में दिक्कत आ रही है और कोई और सोर्स नहीं है उसे समझने के लिए. एट दैट वेरी मोमेंट वी विल टर्न टू द प्रियम्बल टू द कॉन्स्टिट्यूशन. बिकॉज प्रियम्बल हमें बताता है हमारे कॉन्स्टिट्यूशन के मेकर्स की इंटेंशन कि हमें किस नज़रिए से हमारा कॉन्स्टिट्यूशन देखना है. तो नंबर 1 बात तो ये कि ना तो प्रियम्बल टेक्स अवे एनी पावर फ्रॉम द गवर्नमेंट, नॉट डज इट गिव एनी पावर टू द गवर्नमेंट. सेकेंड थिंग इज दैट प्रियम्बल इज नॉन जस्टिसिएबल. दैट इज हम प्रियम्बल का नाम लेके केस नहीं कर सकते. हाँ, हम ये कह सकते हैं कि मेरा राइट टू इक्वालिटी वायोलेट हो गया आर्टिकल 14 के अंदर, मैं सुप्रीम कोर्ट में केस कर सकता हूं. हाउएवर प्रियम्बल के नाम पे कभी केस नहीं होगा. केस हमेशा एक प्रॉपर आर्टिकल या किसी कानून के द्वारा होगा. नाउ आफ्टर दिस आई एम गोइंग टू प्रोवाइड यू विथ 2 tables. द फर्स्ट टेबल इज sources of constitution and the second table is schedules of the constitution. With the brief background of legislations that came before constitution, the preamble and sources of constitution along with schedules to the constitution. If we are able to do all of these things in one day or through one lecture, let me assure you this is going to cover about 3 to 4 questions from your entrance exam. This is perhaps the most productive part of this entrance exams syllabus. Now, I would not be explaining you all these terms as of now, because these are again legal terms which we will be studying as and when in our coming lectures. However, you should go through these words and try and learn them and try and relate to them through my future lectures. After completing the entire course with respect to constitution, I will come back to these tables so as to make it more clearer to you. Schedules of the constitution. Now, in the beginning, the constitution had 395 articles divided into 22 parts and 8 schedules. However, ours is a living constitution. एक फीचर है हमारे कॉन्स्टिट्यूशन का जिसे कहा जाता है लिविंग कॉन्स्टिट्यूशन. हमारे कॉन्स्टिट्यूशन आने वाली परिस्थितियों के साथ बदल सकता है, इसमें ऐसे प्रोविजंस हैं. और इन्हीं प्रोविजंस का फ़ायदा उठाते हुए और इन्हें यूज़ करते हुए हमारे कॉन्स्टिट्यूशन में सेवरल अमेंडमेंट्स के थ्रू नए नए आर्टिकल्स जुड़े, नए नए स्केड्यूल्स जुड़े। स्केड्यूल्स लिस्ट्स हैं बेसिकली। सो this is a list of the 12 schedules. At the time of independence, we had only 8 schedules. 8th schedule tells us about the 22 languages recognized by the Constitution. 7th schedule tells us about the 3 lists in which the powers of the center and the states are divided. If you remember, just some time before, we read about Government of India Act 1935 and how that very act divided the powers between the central and the provincial governments into 3 lists. The same idea is taken from there and incorporated in Schedule 7, dividing the powers of the central and the state government between central list, state list, concurrent list. Then we have the 10th schedule. Now 10th schedule is very important in today's respect and has always been important. आप लोगों ने आया राम गया राम की बात सुनी होगी। अब आया राम गया राम क्या होता है? कभी भी अगर हमें सरकार बनानी है, चाहे वो स्टेट असेंबली में बनानी हो या फिर पार्लियामेंट में बनानी हो, हमें चाहिए होती है मेजॉरिटी। तो जब किसी सरकार को, जब किसी पार्टी को पूर्ण मेजॉरिटी नहीं मिलती है, तब होते हैं कुछ ऐसे लोग जो कि पोजीशन के लालच के अंदर अपनी पार्टियां बदल लेते हैं। आया राम गया राम भी एक ऐसी ही कहानी है जिसमें एक महापुरुष ने 3 दिन के अंदर 3 पार्टियां चेंज कर ली थी। इस चीज को रेक्टिफाई करने के लिए और सरकारों की स्टेबिलिटी बढ़ाने के लिए, हॉर्स ट्रेडिंग से बचने के लिए शेड्यूल 10 लाया गया, which provides for disqualification of members of parliament and state legislatures. ठीक है? Schedule 11 और Schedule 12 incorporate करता है पंचायत और म्युनिसिपैलिटीज। महात्मा गांधी का सपना था पंचायती राज सिस्टम का। महात्मा गांधी चाहते थे कि देश की सरकार देश के विलेजेस से होकर निकले, लोकल गवर्नमेंट्स बने। लोकल गवर्नमेंट्स का ये फायदा होता है कि जो डिसीजंस लोकल लेवल के होते हैं वो वहीं पे सॉल्व हो जाते हैं। इसी चीज को देखते हुए कॉन्स्टिट्यूशन 73rd अमेंडमेंट एक्ट एंड 74th अमेंडमेंट एक्ट ने पंचायती राज सिस्टम एंड म्युनिसिपैलिटीज का गठन किया और एक फिक्स्ड सब्जेक्ट्स रखे जो कि स्टेट और सेंटर को अपनी पावर्स के खाते में से इनको देने पड़ेंगे, thus providing panchayats and municipalities a constitutional status. शेड्यूल्स के संदर्भ में शेड्यूल 1 आज की डेट में और एग्जामिनेशन पॉइंट से बड़ा इंपॉर्टेंट है। शेड्यूल 1 हमें बताता है नेम्स एंड टेरिटोरियल एक्सटेंट ऑफ 28 स्टेट्स एंड 8 यूनियन टेरिटरीज। नाउ रीड दिस केयरफुली। टुडे वी हैव 28 states and 8 union territories. Schedule 1 हमें भारत की टेरिटोरियल सीमाओं के बारे में बताता है और इंटरनल विभाजन क्या है विद इन डिफरेंट यूनिट्स उसके बारे में बताता है। विद द डिसऑर्गेनाइजेशन ऑफ with the making of the state of Jammu Kashmir into union territory, there were addition of 2 union territories, which was union territory of Leh and Ladakh and the union territory of Jammu and Kashmir, which took the earlier number to 9, from 7 to 9. However, thereafter, the union territory of Daman and Diu and Dadar and Nagar Haveli were joined into one union territory, and therefore we came to the number 8 union territories. And Telangana, if we remember, was the 29th state. With the making of the state of Jammu Kashmir into a union territory, we are today left with 28 states. Apart from this, do take a cursory read of all other schedules, and if you are able to cover up this lecture, I can assure you that 3 to 4 marks are done. That would be all for today. I'll meet you with new lectures every day from coming onwards, and we'll be completing the syllabus as fast as possible. Thank you and all the best for your preparation.